Good morning, Mr. Silverthorne, Ms. Smith. How are you guys?
Good morning, Judge. Well, thank you.
Good morning, Judge. I'm doing fine, thank you.
All right. Are we ready on the Parks case?
Yes, Your Honor.
Yes, Your Honor.
All right. And I see Mr. Parks is here, so I'm going to call, make sure I get the right date here. It's the 11th. So on the record in docket 22-01-938, that is People of the State of Michigan versus Corey Randall Parks. Will the parties please introduce themselves for the record?
Yes, good morning, Your Honor.
Hi.
Melanie Smith here on behalf of the people.
Good morning, Your Honor. Dwayne Silverthorne from the Office of Public Defender on behalf of Corey Parks, who I see is also appearing on screen.
All right. And
Good morning, Your Honor.
Okay, and sir, you are Corey Parks?
Yes, Your Honor.
Okay, do you have video, Mr. Parks? I'm just curious.
I do. It was kept cutting out when I tried. Let me go ahead and try again. I was just hoping it didn't slow down the connection.
All right, that's fine. I'm good with hearing you. I just wanted to make sure that I think that was the reason that you don't have video is because there'll be some video problems. But
Yes.
I'm good with this today. My understanding. Well, this is the time set for preliminary examination. Ms. Smith, how are we proceeding today?
Thank you, Your Honor. Today, I believe the defense would like to make a motion to adjourn the preliminary examination, which the prosecution has no objection to. And then we would just ask that the defendant waive his 21-day timeline.
Mr. Silverthorne?
That is correct, Your Honor. And the basis for the request is to time to review discovery. I still have more coming in. I think we might have gotten some from the prosecution discovery unit that came in a different fashion and may have been misplaced, and we're rectifying that. But basically to give me more time to review discovery.
All right, and Mr. Silverthorne, you don't have any objection to taking the 21-day waiver over Zoom? I don't have to swear your client in or anything, but you have no objection to that?
Absolutely not, Your Honor. That's fine.
All right. So may I inquire of your client concerning the 21-day waiver, Mr. Silverthorne?
Please, Your Honor. Yes.
Mr. Parks, you understand that you have the right to a preliminary examination, which is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime was committed and the identity of the person who committed that crime. You have a right to that
Yes.
prelim within 21 days. Do you understand that, sir?
Yes, Your Honor.
And if we adjourn today, then we will be holding that prelim outside of that 21-day right. You will still have that prelim day, but you will not have it today. You'll have it outside of 21 days. And that would be in order for discovery to be complete and for your attorney to be able to review all the information from the prosecutor. Do you understand that?
Yes, sir.
And it's my understanding today that you're willing to waive your right to a preliminary examination today within 21 days.
Yes, that is correct, Your Honor.
All right. So you agree you're waiving your right to a preliminary examination within 21 days. We'll set it for a new date. Mr. Silverthorne, do you have any idea? Maybe 2-3 weeks concerning this matter. Ms. Smith, just some input on a date.
2 or 3 weeks. I'm open Friday the 20th. Would this be a Friday?
It'll be a Thursday, most
Thursday?
likely.
Oh, that's okay. Thursday the 25th is good. And
We could put it because it is a vertical. We could also put it on a Tuesday afternoon, so we could give it its own slot.
either of those are fine. If the court has
All
some
right.
dates, I can probably approve them right now.
Your Honor, I would just note that I am in a week-long training from the 22nd to, I guess actually it's a little bit longer than a week because it goes all the way to the 31st. So I would be free on Thursday the 1st or anytime the following week.
All right, let me check and get our dates. Next week after next.
She's in training.
Right, so that week's out.
Yeah. So we need to do Thursday the 1st.
So Thursday the first. They didn't ask for that. All right, 9/1/8/30. So how does September 1st at 8:30? 9/1/8/30.
Great for me, Your Honor.
I'll be in the court on another PE that day, so that would be fine.
All right. So I will, Mr. Parks, I will see you back in courtroom on September 1st at 8:30. Anything else for the record, Ms. Smith, 2201938?
Thank
Anything,
you.
Mr. Silverthorne?
Nothing, Your Honor. Thank you.
All right, thank you. Everybody have a nice day.
You're
Thank you for your appearance.
Okay.
Thank you,
You're
Mr.
welcome.
Parks. So we're on the record in docket 22-01220. People of the state of Michigan versus Mary Lou Riemenschneider. Will the parties please introduce themselves for the record?
Jake Westy on behalf of the people.
Good morning, Your Honor. Jacob Sarge, the fourth Assistant Public Defender, filling in for Stephen Feigelson. Mr. Feigelson sends his apologies, Your Honor. He's a little under the weather this morning. He cannot appear in person. And it's my understanding that Ms. Snyder is in the process right now of finishing up retaining Vincent Green, Your Honor. And it's my understanding that Mr. Green had some scheduling issues this morning. Otherwise, he would have been here. So I'm going to be requesting an adjournment of these proceedings. It's my understanding there would be no issues with the timeline. And this is Ms. Riemenschneider.
Miss Riemenschneider, Your Honor.
Riemenschneider. My apologies
You're
again.
actually doing a lot better than most.
Riemenschneider's choice to retain counsel. I don't think the delay here would be particularly prejudicial to the people at this time. And I would just request that these matters be adjourned. Thank you.
All right. Mr. Witzy,
No objection to an adjournment under the circumstances.
what are we on these days? So this case right now is at day 76 with several adjournments. I agree that Ms. Freeman Schneider should have her choice of counsel if she chooses. My understanding is Mr. Green has not been retained at this point. Is that correct?
Yes, sir. I spoke with Mr. Green yesterday and he agreed to take on my case. I'm either going to meet up with him today or tomorrow, just depending on his schedule. So, or just go straight to his secretary and have the paperwork signed.
All right. There's an indication, and my office will contact Mr. Green.
Yep.
We're not going to give any more adjournments. All right.
Yes, sir.
We're at 76 days. So, I mean, once the case gets 3 months old, we got a problem.
I
Okay.
understand.
So I'll grant the adjournment with the understanding that, and we're going to give you a new date with the understanding that Mr. Green knows he's going to come in here, he's going to waive, he's going to do a prelim, he's going to do something. Okay.
I am to call him as soon as I leave here.
All right. And then there's one other matter we have to discuss concerning a probation violation. So I want you to clear that up before you come see me again. Okay, but we'll
Okay.
talk about that. Okay, so I'm going to grant the adjournment. So it'll be set for September 2nd at 8:30. And you'll get notice of that. Make sure Mr. Green gets that because that's a big date for him.
I will, sir.
To retain Vince Green. And then on this file, so September 2nd at 8:30 is the adjourned date. On this file, I have that you are not under monitoring anymore. That they've ceased to put you on monitoring for lack of paying.
I was put on the indigent program. Your Honor.
All right, whatever, right now I've got you I've got a memo from the pre-trial service investigator that you're under violation of bond because you're not being monitored by GPS. Whatever that is, we need to clear that up.
Yes,
Okay,
sir.
we've got to clear it up. So, so that Nicole Gunther from Pretrial Services is the one who sent the memo. So I would go right here, right down there, and I would clear this up. Because I expected an email from Ms. Gunther this afternoon indicating either they're violating your bond or this is cleared up, all right? And it looks like the monitor was shut off because of non-payment. So if that's an issue, address it with Ms. Gunther, okay?
Okay. not
All
a
right.
problem.
All right, so we have,
I'm sorry. Where is she located at downstairs?
she'll be on the, no, she's at the county. Do you know what floor she's there?
Mason?
Yeah,
Okay.
she's actually at the circuit court at 303 West Kalamazoo. So she's actually at the Grady Porter courthouse.
I'll go
all right?
straight there after here. Your Honor.
Yeah, do, and just clear it up with her,
I
whatever's
have to
going
check
on.
it today
All
anyways.
right. Anything else for the record, docket 22-01220, Mr. Wisty,
No, Your Honor.
Mr. Sarks?
Nothing further. Your Honor.
All right, thank you for your appearance. We will see you again on September 2nd, ma'am, okay?
Thank you.
All right, thank you. So we're on the record in docket 22-01851. People of the state of Michigan versus Karan D. Elston. Will the parties please introduce themselves for the record?
Jake Wisty on behalf of the people.
Good morning, Your Honor. Rico Neal, appearing on behalf of Mr. Elston, who is present standing to my right.
And sir, you are Karan D. Elston?
Yes.
Okay, and I pronounced that correctly?
Yes.
All right, thank you. Well, Mr. Wisty, this is the time set for preliminary examination. How are we proceeding today?
We will be proceeding with the prelim, Your Honor.
All right. So is that correct, Mr. Neal?
That's correct, Your Honor.
Okay, so, Mr. Wisty, the court will allow you to take to take proofs on the motion for bind over.
Thank you, Your Honor. I would be calling Officer Jacob Markenny, who's in the waiting room.
All right.
Your Honor, just a brief motion for sequestration. I don't see any other people in the courtroom, but should anyone else enter?
All right, now I'll ask everybody to raise their voice. I'm gonna have that fan. Nathaniel, can you turn off the fan? Because just to make sure we're recording okay, that was a motion for sequestration. I don't see anybody in the courtroom, but if there's anybody in the courtroom who has any witness association to this case, you'll have to leave the courtroom for the proceeding. Ms. Robinson's a public defender, and I think the other individual came with your clients. Okay. All right, Mr. Wisty, what's the name of your first witness?
Jacob Markenny.
And you have somebody getting him?
I was just going to.
Okay.
You need the spelling of that?
I'll ask him when he comes up and we swear him in. It's Officer Marquetti.
Yes, sir.
All right. I'm gonna have you stand right in front of me. First, I'm gonna have you state your name and spell your last name for the record. It's really so the court recorder gets the name correct.
Absolutely.
Okay, so your name is?
Jacob Markini. It's JACOB MARCKINI.
Okay, and that's Marquini, is how you say that.
That's correct.
Okay, I'm gonna have you raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
All right, sir, you can have a seat. I'll have you speak up as loudly as you can. The recording's not for audible purposes, it's for recording purposes.
Okay.
And Mr. Wisty, you can proceed.
Thank you, Your Honor. Just state your name for the record if you didn't already do so. Yes, Jacob Markini. What do you do for a living? I'm a City of Lansing police officer. How long have you been in that position? Approximately 4 years. In that capacity of that position, did you come in contact with the defendant Karen Elston on July 13th, 2022? Yes, I did. You recognize Mr. Elston today in the courtroom? I do. He's wearing the plaid checkered shirt sitting at the defendant's table. The record reflected the fact or the witness has identified the defendant.
Any objection? Without objection, the witness has identified the defendant.
And how did you come in contact with Mr. Elston that day? I was assigned to a marked patrol car and observed a vehicle failed to signal a turn from Shiawassee to Cedar. And what did you do as a result of observing that? I pulled behind the vehicle and I also noticed that the back driver's side tire was canted inward and wobbling. It didn't appear to be safe to be operated on the roadway. And as a result of noticing those things, what did you do? I initiated a traffic stop.
Okay, Mr. Wisty, I'm gonna have you keep your voice
Okay,
up.
I'm sorry.
Yep.
So after you initiated the traffic stop, what happened next? At that point, I made contact with the driver while I was speaking with the driver. I noticed the passenger, Mr. Elston, appeared nervous. He was breathing heavily. Returned to the vehicle. My partner had obtained his information. I ran that information in the computer and determined that Mr. Elston had an outstanding juvenile detention order. What happened from there? From there, we went back up to the vehicle, made contact with Mr. Elston, had him step out of the vehicle to discuss the situation with him. At that point, I was informed by another officer that there was a visible firearm protruding from underneath the passenger seat. And at that point, what did you do? At that point, I detained Mr. Elston in handcuffs. What happened to the firearm? We conducted a probable cause search on the vehicle and we collected the firearm as evidence. What happens to it after you collected that evidence? We submit it to our evidence at the police department, protected for forensic DNA, and it's ultimately submitted to the lab for analysis. A permission to approach, Your Honor.
You may.
Officer, I'm going to show you a couple of photographs.
Do you want those marked?
Oh, yes, please.
Yep, so let's mark those as People's Exhibit 1 and 2. Okay, so I'm handing it back to council, the exhibits in marked 1 and 2.
Thank you, Your
You're
Honor.
welcome.
May the record reflect and showing the witness with marked as People's Exhibit 1.
Record may so reflect.
Thank you, Your Honor. Can you tell me what that is? Yes, that is the firearm that was seized from under the passenger seat of the vehicle. And then may the record reflect and showing the witness which been marked as People's Exhibit 2.
Record may so reflect.
Thank you. Can you tell me what that is? It's a photo of the same firearm with just zoomed in on the serial number of the firearm. This time I'd like to submit People's proposed exhibits 1 and 2 into evidence.
Any objection, council? Without objection, People's Exhibit 1 and 2 are admitted into evidence.
No further questions.
Cross-examination.
Morning, officer.
Morning.
Officer, I want to take you back to the day of July the 13th, 2022. Recall that day.
I do.
That's the day you indicated that you were working for LPD.
Yes.
And at that time, you indicated you observed a vehicle that you subsequently made a traffic stop on for failing to use a turn signal.
Initially, that's what drew my attention to the vehicle, and then I noticed that the rear wheel was canted inward and wobbling.
And that was the basis for your stop, correct?
Yes, sir.
How many occupants were in that vehicle?
There were two.
Two occupants. Do you, one being my client,
That's correct.
who was seated in the passenger seat,
Yes.
the other being a driver of that vehicle.
Yes.
Do you know who the driver was?
Not off the top of my head, I'd have to refer to my report.
Okay. Now, subsequently, you made contact with the occupants of that vehicle. In making contact, did you run the registration or the ID of the driver?
Yes.
Did you, after running the identification of the driver, did the driver have any warrants or anything?
Not that I'm aware of.
Was the driver subsequently arrested at all that day?
No.
He was released?
Yes.
Safe to say, safe to assume, based on him being released, he didn't have warrants or anything, is that correct?
That's correct.
Had he had warrants, we would have arrested him.
In most circumstances.
Okay. Now, you then, did you determine whether or not the driver had warrants prior to re-engaging with my client?
I ran, if I remember correctly, I ran both of their names. That's usually how I operate.
And upon running both of their names, you indicated that you observed or were made aware that there was an app order out for my client.
That's correct.
Is that then when you then re-engaged with my client?
Yes.
Well, let me back up. At the same time that you were running the identification of the two occupants, did you ever run the registration of that vehicle?
Whatever, yes.
Was that, do you know who the registered owner of that vehicle was?
I don't recall, but it was not Mr. Alston. That's what you're asking.
Would that be information that you would have listed in your report?
Generally, yes.
Okay. Permission to approach.
You may.
And I'm handing you what's Lansing Police Department report. You take an opportunity to review it. After you have an opportunity to review it, please look up. An opportunity to review your report.
Yes.
Can you tell me who the registered owner of that vehicle was?
Does not look like that I listed who the registered owner is in the report.
That would be, when you consider that to be a critical piece of information.
Wasn't really relevant in this scenario.
It's not really relevant that whoever the registered owner of the vehicle is, of a vehicle you found a gun inside is not relevant to you.
It was not registered to your client. If that's what you're asking.
Car.
Correct.
So you do know that the car was not registered to my client,
I do.
not his car.
Correct.
Who was the gun registered to?
Jacob Weck.
Did you write that in your report too?
Yes.
Now, you went back subsequently and then you re-engaged with my client on this app order. Were you alone at that time you re-engaged with him?
I was in a two-man car that day.
Who was with you?
Officer Rick Samuel,
What time of day was it?
early evening.
Early evening. What time was speak?
Let's say it was around 8:30-ish, if I remember correctly.
What was the lighting like?
Still daylight.
Still daylight? When you first initially approached that vehicle, you didn't see any firearms, did you?
No, I did not.
You didn't, well, let me back up. You yourself personally never saw any firearms.
Not until I was alerted by another officer.
Okay. When you were alerted that there was a firearm in that vehicle, did you ask either of the occupants if they had a CPM?
Not until after we had secured everybody for their safety.
Find out whether either occupant had a CPM?
Yes, neither did.
You reapproached his vehicle. Was my client still seated in the passenger seat?
Yes, he was.
And you approached it from the rear, I'm assuming,
Yes.
the rear passenger seat?
From the rear of the vehicle on the passenger side of the vehicle.
Right. And upon approaching it from the rear, you could clearly see inside the vehicle, correct?
Yes,
Where was your partner?
somewhere near me, approaching. at the
Was he in
same-
front of you, or was he on the side of you? Was he behind you?
He's on the side of me.
He was on the side of you.
Correct.
Did he exit your vehicle and approach the vehicle with you?
Yes,
And the both of you got back up to the passenger side of this vehicle at the same time?
yes,
And it's at that point in time, you're indicating that you were alerted by your partner.
not by my partner as in Rick Samuel. Sergeant Trooper Zisman of the state police was also present. I believe he was standing at the vehicle watching the occupants while I was running the individuals.
There were more officers there.
Yes, sir.
How many total officers were present?
I believe 4.
4. You, your partner, Detective Trooper Samuels, as you indicated.
Myself, Officer Rick Samuels, Sergeant Trooper Zisman of the state police, and his partner, I believe he had, I don't recall who we had with him that day.
So you and your partner went back to your vehicle to run the information of the occupants,
Yes, sir.
correct?
Yeah.
Where were the other 2 officers while you were running the occupants?
They remained up at the vehicle.
They remained at the vehicle.
Yes.
So the entire time, someone had eyes on these occupants, correct? Either
My
you
knowledge.
or the other officers.
To my knowledge, yes.
When you first initially approached these occupants, did you see either one of them put anything under any seat?
I did not.
Did you ever see anyone put anything under a seat?
No.
Okay. To your knowledge, did anyone else see anybody put anything under a seat?
Not to my knowledge.
So you don't know how long that firearm may have been under that seat.
I do not.
And that vehicle was not registered to my client.
That's
correct?
correct.
Do you know where they were coming from prior to your stop?
I don't know that I know where they were coming from. I believe they said they were on their way to play basketball.
So you don't know how long my client had been in that vehicle.
Personally, I did
He had just gotten in. Would that be shocking to you?
not. Could be, very possible.
Is this the first time that you've ever stopped that vehicle on any other occasion?
To the best of my recollection, yes.
You've never stopped that vehicle any other time?
Not that I remember.
So at no point in time did you ever see my client with a firearm, did you?
No.
You never saw him put anything under the seat.
I did not.
So the only basis that you have for him and connecting him to the firearm is just proximity to where he was seated?
Yes.
No further questions, Your Honor.
Any redirect? Thank you, Counselor.
Yes, Your Honor. And then was there anything besides just proximity that made you think that the defendant may been in possession of the firearm?
Just based on his demeanor, when I approached the vehicle, he was breathing very heavily. Generally, that indicates to me that they're nervous for one reason or another.
Anything else to elaborate on that?
No.
Nothing further, Your Honor.
One question, that this stop was at Kalamazoo East Street?
Yes, sir.
All right, and that's in the city of Lansing, Union County, state of Michigan.
Yes, it is.
All right. May this, any recross?
So
May this witness be excused?
Yes, Your Honor.
Without objection, the witness is excused. Any further proofs, Mr. Wisty?
Yes, I'll be calling Trooper Zeisman, Your Honor.
All right,
May I have a excuse to?
sure. Yeah, I'm gonna call him. Trooper Zeisman, I'm gonna have you stand right here and state your name and spell your last name for the record.
Scott Zisman, Ziesman.
All right, and raise your right hand. You solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury.
I do.
All right, thank you. May I have a seat, sir? And that microphone is for recording purposes, not auditory purposes, so keep your voice up if you can.
Yes, sir.
When you're ready to proceed, Mr. Wisty.
Thank you, Your Honor. Good afternoon, or good morning, Sergeant. Could you state your name for the record if you didn't already do so?
Scott Zisman, I already did so.
Where are you employed?
The Michigan State Police,
How long have you been there?
about 24 and a half years now.
And were you working in that capacity on July 13th, 2022?
Yes, sir, I was.
Did you come in contact with Karan Elston that day?
Yes, I did.
You recognize him here today in court?
Yes, I did.
Could you point him out and identify something he's wearing?
He's seated at the table there with a black and white and gray checkered shirt on.
Can I ask where you came in contact with him?
I was backing up Lansing Police Department VCI unit on a traffic stop
Where did that occur? What city?
in the city of Lansing here. It was
That's
on
me.
Kalamazoo Street.
And when you got to that scene, what did you do when you first arrived?
I made contact with the officers. They were in the process of running a lean check on the driver and passenger.
And from there, what did you do?
They had a juvenile detention order, which was a little confusing to all of us as the person was now an adult. So they were getting him out to discuss that lien order with him.
Well, they were getting him out. Did you observe anything inside the vehicle?
Once he was outside of the car, I observed a firearm underneath the passenger seat of the vehicle.
Let me approach, Your Honor.
You may. Did you want those marked?
Yes, please. Your
All
Honor.
right. So I'm gonna have these
Three.
marked exhibits 3 and 4. I'm handing back what's been marked as people's exhibit 3 and 4. And for the record, they have been shown to defense counsel.
Thank you, Your Honor.
You're welcome.
You can take a look at now. Sergeant.
Mhm.
Tell me what you're looking at.
That's the seat and the floorboard and the base of the firearm that I observed in that vehicle.
Is that identified as people's exhibit?
Yes, it is.
Your Honor, at this point, I'd like to move to put exhibit 3 in evidence.
Motion to admit people's exhibit 3. Any objection? Without objection, people's exhibit 3 is admitted into evidence.
May the record reflect I'm showing the witness that what's been marked as people's exhibit 4. Tell me what that is.
That's a closer up picture of that firearm as it appears underneath the seat.
This time the people would move to admit people's exhibit 4 into evidence.
Any objection? Okay. Without objection, people's exhibit 4 is admitted into evidence.
That firearm was located under the passenger seat, is that correct?
That is correct.
Who was sitting in the passenger seat?
Um, the defendant was.
I have no further questions, Your Honor.
Cross-examination.
That's his photograph, John.
I'll provide all 4 exhibits. Thank you.
Trooper, now you indicated you were working on this particular day, July the 13th, correct?
Correct.
And you were assisting LPD officers on a VCI traffic stop.
That's correct.
You were backup, correct?
That is correct.
And you approached this vehicle, how many subjects were in that vehicle?
There were 2 people in the vehicle,
Where was my client?
in the passenger seat.
So, and there was another individual, I'm assuming was the driver.
Correct.
At the time that you approached, you indicated that the LPD officers were running a lean on the individuals in the vehicle. Is that correct?
Correct.
And you maintain visual eyesight on both of the occupants of the vehicle, correct?
I was watching the vehicle while they were doing that.
You can see the occupants, correct?
Yes, I can see.
And you can see both of the occupants and their hands and what they were doing, correct?
At that time, they were in the vehicle, so I would say I could not see their hands.
They weren't making any sudden movements that caused you any alarm, were they?
No,
Not, you didn't observe either of the occupants, more specifically my client attempting to place anything under the passenger seat. Did you?
I'm sorry, can you say
Didn't
the
observe.
question again?
You didn't observe my client place anything under the passenger seat, did you?
No, I did not.
Now, you said he was removed from the vehicle and you subsequently saw a firearm under the passenger seat as he was removed, correct?
That is correct.
And based on his proximity to that firearm, is that your assumption that he was in possession of the firearm because of where it was located in proximity to him?
I'm sorry, I don't understand the question.
Are you making a determination that he was in possession of that firearm based on the location in proximity to where he was seated?
Yes, sir. I would say that that was his firearm based on the fact that it was within inches of him where he was seated in the car.
Okay. And he was been marked as the People's Exhibit number 3. Recognize that photograph, correct?
Yes, sir.
Did you take that photograph or did someone else take it?
I believe Officer Marquini took that photograph.
In that photograph, you see the firearm under the seat, correct?
That is correct.
See anything else in that photograph?
See a floor mat, I see a phone, I see a phone charging cable. See the car seat, I see the seatbelt buckle, I see a parking brake.
You see a phone, you see a charging cable, correct?
That is correct.
Where's the phone?
On the top of the cup holder and partially on the passenger seat.
Is the charging cable also connected to that phone, correct?
That is correct.
This charging cable is partially on the passenger seat as well, correct?
That is correct.
Whose cell phone is that?
I have no idea, sir.
Whose charging cable was that?
I have no idea, sir.
But you're able to say because the gun was under the seat that he was seated in, that that's his gun.
Yes, sir.
But you can't say that same cell phone sitting on top of the seat along with the charging cable, sitting on top of the same seat is his cell phone or his charging cable.
No, I cannot.
No further questions, John.
Any redirect?
No, Your Honor.
Okay, may this witness be excused?
Yes, Your Honor.
Without objection, the witness is excused. Do the people have any further proofs?
No, Your Honor.
Do the people rest?
Yes.
Does defense have any proofs today?
No proof, John.
All right. Motion for bind over.
Yes, the people would move to bind over on count 1, weapons carrying concealed. I believe there's been enough shown for the standard of probable cause to bind this over. The elements are knowledge and that he had a firearm that was concealed or in a vehicle. Here we have a vehicle found under the passenger seat where the defendant was sitting. Defendant appeared nervous. Based on that, I believe that's enough to get us to probable cause, Your Honor. I would remind the court that's a much lower standard and reasonable doubt to issues may come up at trial. But at this point, I think there's enough to believe the crime was committed. And the defendant is the-
All right. Thank you, Mr. Wisty. You were kind of lowered down. You're kind of a little softer spoken at the end of that, but response to motion for bind over.
Thank you, Your Honor. We would actually ask the court to respectfully deny the motion for bind over. There was a traffic stop made on this particular vehicle with two occupants of this vehicle. At the time that this vehicle was stopped, officers had a visual eyesight on the occupants of this vehicle at all times, either by the initial stopping officers or by the subsequent MSP officers who arrived to assist. At no point in time did any officer here testify that they saw my client or any occupant of that vehicle place any objects under the seat of that particular vehicle. The vehicle was not registered to my client, nor was the gun registered to my client. Interesting enough, when the prosecution argues that my client has to have knowledge, there hasn't been any showing that he knew or had knowledge of the firearm which was located under the passenger seat of that vehicle. It's even more telling, Your Honor, that both officers indicated that they made the determination that that particular firearm belonged to my client simply based off of proximity to where the firearm was located and to where he was seated. However, as testified to by the trooper, there are other items that were located on that seat itself in which he was sitting in, specifically the cell phone as indicated in the People's Exhibit number 3 and the charging cable that's seated on the same seat. But the trooper could not say that the cell phone or the charging cable was not my client's, as just as definitive as he could say that the firearm is my client's just because of where he was seated. I don't believe there's been a probable cause. People have met the probable cause standard. We'd ask court to deny the motion.
Thank you. Any response?
Yes, Your Honor, I would just say, I think there's a difference between a cell phone on the center console and a handgun at the seat of the passenger seat. And I would point out that in addition to proximity, there was the officer testified that the defendant appeared nervous. I think that's indicative. Proximity plus that is enough for probable cause, Your Honor.
Thank you. Well, of course, the standard for preliminary examination is probable cause. That's the second lowest standard in our criminal justice system. Beyond a reasonable doubt, which is the standard for conviction being the highest, probable cause being the second lowest. The question concerning so I don't think there's any questions concerning the location at Kalamazoo, East Street, City of Lansing, Ingham County, State of Michigan would take care of location and venue. The defendant was identified as the individual in the courtroom and the person alleged of the crime. The date of July 13, 2022 has been met. So the only thing are the offense of the crime. We had two witnesses testify, Officer Jake Martini and Sergeant Trooper Scott Ziesman, indicated that the firearm in exhibits 1 through 4 were found underneath the passenger seat, the same seat that the defendant was indicated that he was seated at. So the real question here goes to knowledge and the inference of knowledge. At a probable cause standard, I believe it's been met. These same facts have somewhat been identified under the case Maryland v. Pringle, which is constructive possession of a firearm at a probable cause standard. So I think the inference can be made. However, it's a much different standard at beyond a reasonable doubt, as both counsel have indicated for the record. I do find there's probable cause evidence to believe that a pistol was in vehicle that the defendant was in. That's by the 4 exhibits in the testimony. I think there's enough evidence to indicate the defendant knew the pistol was there. That inference is based on the testimony of the troopers and the 4 exhibits. It's an inference only at this point in time, based on behavior and based on where the pistol was found. And there is an inference the defense took part in carrying or keeping the pistol in the vehicle. That is at a probable cause standard, the lowest standard, that those are all trial issues that would be addressed at a beyond a reasonable doubt standard. However, I believe that the defendant is correctly bound as charged and will be bound over as charged on count one. And I believe the probable cause standard, the lower standard, has been met in these proofs. I will not give a date for bind over because the circuit court sets that date, if I'm correct, Mr. Neal.
That's correct.
Okay, and so this case is bound over to circuit court. You'll get your date, sir, from your attorney, Mr. Neal. Okay, he will indicate for you what date you should appear in circuit court. Is there anything else for the record, Mr. Wisty?
No, Your Honor.
Anything, Mr. Neal?
Nothing further.
All right.
Thank you.
All right, thank you. That's all for the record in this file.
Thank you.
All right, Mr. Grable, we're on the record. Just for your purposes, we still don't have an appearance in the file that has made it to the file.
I've emailed it and it hasn't been kicked back. Let me confirm the email address because I did
All
send
right.
it out again. So if the court, I apologize. I did send it out as soon as we finished the other one. So
No worries. I mean, I know you've been retained. I just want to make sure that the
no,
file.
I've sent it out twice. Let me confirm the email. I apologize.
All right.
I sent it 54a.criminaltraffic@michigan.gov. It did not kick
I
back. I'll
think-
send it again. Is that incorrect?
Yeah, let me give you another. So
I apologize, Your Honor. I'll send it out immediately right now.
He said it proves it's 54A.criminaltraffic@lansing.mi.
Okay, so say it again, 54.
54A.criminaltraffic@lansing.mi.gov.
All right, well, now I see the thing. Okay, I at lansingmi.gov. I'll send it out right now.
All right, thank you, Mr. Grable. And so if we're ready to go on that case, we'll call docket 22-01830, People of the State of Michigan versus Mark Jordan. Will the parties please introduce themselves for the record?
Jake Wisty on behalf of the people.
Attorney Scott Grable, P53-310 on behalf of Mr. Jordan, Your Honor. We'll be waiving the prelim this morning.
All right, and you are Mark Jordan, sir? You're gonna have to take yourself off mute.
Can you hear me now?
I can. You are Mark Jordan, sir?
Yes, I am. Sorry about that.
You can hear me all right, Mr. Jordan?
Yes.
How are we proceeding today, Mr. Wisty?
My understanding is the defendant will be unconditionally waiving his prelim and it'll be sent up to circuit court.
And is that your understanding, Mr. Grable?
It is, Your Honor.
And you have no objection to the waiver being conducted over Zoom?
We do not, Your Honor. Client waives his
All right.
appearance to be present by Zoom today. Correct.
All right, thank you. May I make inquiry of your client concerning the waiver?
You may, Your Honor. Thank you.
All right, thank you. So, sir, you understand you have a right to a preliminary examination in this case. And in that, if you waive your right to a preliminary examination, you'd be waiving your right to have a hearing in which the people would have to prove by probable cause evidence that a crime has been committed and probable cause evidence that the identity of the person who committed that crime. You understand? You understand that's the nature of the preliminary examination you'd be waiving today, sir.
Yes, I do.
And you are represented by Attorney Scott Grable. Of course, he would cross-examine any witnesses that would be brought against you, and he would contest any charges. And he would be available to speak to you about any issues arising from the probable cause hearing. You understand that when you waive your right to preliminary examination, you'll be going to circuit court, and you will leave district court in its entirety to continue on to circuit court, which is the trial court in this matter. Do you understand that?
Yes, I do.
Do you wish today to give up your right to a preliminary examination and to waive that right to preliminary examination and to go on to circuit court where negotiations will continue?
Yes, I do.
Okay, I find the waiver of the preliminary examination to be knowing, voluntarily, and understandingly given. Anything, Mr. Wisty, concerning the waiver?
No, Your Honor.
Anything, Mr. Grable, concerning the waiver?
No, Your Honor. Thank you.
All right, Mr. Jordan, you've waived your right to preliminary examination. You're now bound over to circuit court, where you'll get your next appearance in circuit court from your attorney, Mr. Grable. So please keep in contact with Mr. Grable, okay? All right, Mr. Jordan?
All right.
All right, the prosecutor also waives their right to preliminary examination, and you'll get any further date from Mr. Grable, your attorney. Anything else for the record in docket 22-01-830, Mr. Wisty?
No, Your Honor.
Anything, Mr. Grable?
No, Your Honor, and I'm emailing over again. I apologize. I'm emailing the appearance over again to the correct email.
All right, thank you, Mr. Grable. No worries about that. As long as, I just want to make sure it reaches the file, okay?
Not a problem, Your Honor. Have a pleasant day.
You too, Mr. Jordan, your next date will be in circuit court. Keep in contact with your lawyer, okay?
All right.
All right, thank you for your appearance. Everybody have a nice day.
Thank you.
You too. Thank you.
All right, we're on the record in docket 22-01-981. That's people of the state of Michigan versus Corey Francala. Will the parties please introduce themselves for the record?
Jake Wisty on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Mr. Fracalla, who is sitting to my right.
And sir, you are Corey Francala?
Yes, sir.
All right.
Just, Your Honor, I'm sorry to correct, is your name Francalla or Fracalla? So there's no N in it?
No.
Okay.
So Fracala,
Fracalla, yes.
Fracala. And no N in it.
Correct.
I'm gonna make that correct. Okay, Fracala, we've got it on the warrant. All right, Mr. Wisty, how are we proceeding today?
There's been an offer made where count one will be dismissed in exchange to a plea to count two. That's a dismissal of the dangerous weapons and a plea to domestic violence. There's a Killebrew agreement to sentencing pursuant to MCL 769.4A. So we'd be proceeding with the plea this morning. The victim is here and would like to address the no contact order with the court.
Okay, so we have a plea to misdemeanor count two, felony count one is to be dismissed.
Correct, Your Honor.
All right, and a Killebrew agreement to 769.4A. Treatment or status, I should say.
Correct, Your Honor.
And Ms. Sutter, is that a fair and accurate statement of how we're proceeding
It
today?
is, Your Honor.
May I inquire of your client about the plea to count two?
Yes.
So Mr. Fracalla, I'm gonna have you stand up. The possible consequences for not going to trial and pleading to just count two are, it's a misdemeanor, 93 days and or $500. Do you understand that, sir?
Sure.
Okay. And there's a plea agreement here that you would plead to guilty to count two, count one is to be dismissed, and then you'd Killebrew to 769 for a status pursuant to that treatment under the domestic assault code. You understand that?
Sure.
All right. And that's your understanding of the plea agreement and what we're doing today.
Sure.
All right. So you have certain rights in this misdemeanor case that you'll be giving right to go to that you will not be doing if you plead guilty. Okay. And I'm going to cover those rights with you. All right. You have the right to have witnesses called in your defense at a misdemeanor trial on the domestic assault case. You have the right to cross-examine all witnesses. You have the right to testify to remain silent without an inference being drawn from your silence. You have the right that your guilt be proven beyond a reasonable doubt by the people of the state of Michigan. Do you understand those rights in this case?
Sure.
And you'd be willing to waive those rights in this case in order to plead guilty today?
Sure.
All right. And you're represented by Ms. Sutter from the Public Defender's Office. She, of course, could cross-examine all witnesses and contest any charges against you. Do you understand that? All right. And you're waiving these rights to plead guilty because you are guilty, sir.
Yeah, sure.
All right. I'm going to bring your attention back. Going to raise your right hand. You solemnly swear to tell the truth, the whole truth, and nothing but the truth under penalty of perjury.
Yeah, sure.
All right. I'll bring your attention back to July 25th, 2022 at 3715 Sandhurst, Apartment 3, City of Lansing, Ingham County, State of Michigan. Were you there on that date at that time?
Yeah, sure.
All right. And were you there with Jessica McClarty, a resident or former resident of the household, or an individual with whom you had a dating relationship with?
Yeah, sure.
Which is it? A resident of the household or a dating relationship?
Both living together.
Okay, so you're living together at the time. The count indicates that you committed assault or assault and battery on Ms. McClarty. Please tell me in your own words what happened in regard to the assault and battery.
We just got into an argument over the laundromat. I didn't mean to touch her or anything like that. People got involved and,
So what happened? An assault is an offensive touching of another or an attempted offensive touching. Tell me what you did to be guilty of count two.
I hit her.
Okay. And when you hit her, it wasn't in self-defense. It was out of anger. You intended to hit her.
Yes, Your Honor.
All right. I find the factual basis to be knowing, voluntarily, and accurate. Any questions on the factual basis, Mr. Wisty?
No, Your Honor.
Anything, Ms. Sutter?
No, Your Honor.
All right. So with the understanding, I'm going to refer to probation. For sentencing, for a pre-sentence to be developed for me to look at for sentencing issues, and then I'll indicate whether I'm willing to follow the Killebrew. At this point, there's nothing that would indicate why I wouldn't. All right, but I want a report done so that I can read it for sentencing purposes. So I'll refer to probation. So you're certain to go to probation, if not today, which I would suggest you do, get there within 48 hours. All right, within 48 hours. So I'm going to refer you to probation within 48 hours. Do we have a sentencing date?
September 26th at 9 a.m.
September 26th at 9 a.m. And I believe the victim in the case is here. Is that right, Ms. Sutter?
It is, Your Honor.
All right. So the victim always has the right to come forward and address the court. Ms. Wisty, did you want Ms. McClarty to come forward and address the court?
Yes, if she desires to do so. Come up just a second.
All right. So Ms. McClarty, I'd have you can stand back there, or you can come back up here by the door and address the court wherever you're comfortable. As long as we can hear you, that's fine. Okay. So ma'am, is there something you want to tell the court concerning the case?
I want to have the no contact lifted.
Okay.
He's been my domestic partner, and I'm concerned about where he is staying other than with me based on some of the aggression that goes on toward him.
All right. So, so you've indicated that for the record. All right, ma'am. I'm referring it to probation. They're going to contact you and they're going to ask you questions concerning some of these issues. All right. So I want you to tell them exactly what you told me. All right. Uh, that will be in writing in a pre-sentence report that comes to me. I'm not willing to lift the no contact order until I see the report because I want what you've indicated in writing to the pre-sentence report. Okay. And then I'll make a decision on that. So at this point in time, the no contact order is in place. All right. The only thing that can lift the no contact order is another ruling of the court. And at this point in time, I'd like to see it all in a report before I lift it. All right. Do you understand that, ma'am?
Yeah,
Okay.
I will, yes.
Okay. So I've heard your request. It's on the record. I'm denying your request today, but that doesn't mean I'm going to deny your request in total. I just want to see the probation officer's report before I do anything. All right. Okay. Thank you for your appearance today, man. Anything else on the record, Mr. Wisty?
No, Your Honor.
All right, so Mr. Fakala, get to probation, make sure they take a report so that I can see it. Protect yourself, so there's a no contact order right now, and then we'll make a determination once I see the reported sentencing, okay? Do you have any questions for me, sir?
No, Your Honor.
All right, Ms. Sutter, anything?
No, Your Honor.
All right, that's all for the record, docket 22-01981. We'll see you on September 26th at 9 a.m., okay, sir? All right. We need Ms. Sutter. We're on the docket and record and number 22019883. People, the state of Michigan versus Cameron Thornton. Will the parties please introduce themselves for the record?
Jake Listy on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Mr. Thornton, who is seated to my right.
And sir, you are Cameron Thornton? All right. Mr. Wisty, this is the time set for preliminary examination. How are we proceeding today?
Your Honor, it's my understanding the defense is moving to have the defendant forensically examined, and we will need an adjournment for that to be accomplished.
Is that a fair statement?
That's correct, Your Honor. I would waive the 21-day timeline today and request 1 week's adjournment to file that petition for conference.
All right.
No objection, and the people waive their 21 days as well.
And that would be for competency and for both competency and
Criminal responsibility.
criminal responsibility.
Yes, Your Honor.
And may I inquire of your client of the 21-day waiver?
Yes.
All right. Mr. Thornton, you understand today you have a right to a preliminary examination within 21 days.
Yep.
And a preliminary examination is a probable cause hearing in which the people of the state of Michigan would have to prove that a crime has been committed and the identity of the person who committed that crime. Do you understand that? You have that right within 21 days. If you waive your right to a prelim within 21 days, you're not waiving your right to a prelim. You're just waiving it within that 21-day period, which is an adjournment you're requesting in order for your counsel to file some paperwork. Do you understand that, sir? Is that a yes?
Yep.
Okay. Are you waiving your right to a preliminary examination within 21 days today?
Yes.
All right. So I find that, and any questions concerning the waiver of the 21-day rule?
No, Your Honor.
Anything, Ms. Sutter?
No, Your Honor.
Okay, so I find the waiver to be at this point knowing and voluntarily made. And then we will adjourn the matter for filing of competency and criminal responsibility that will follow the file. Anything else for the record, Mr. Wisty?
No, Your Honor.
Anything, Ms. Sutter?
No, Your Honor.
All right, that's all for the record, 22019883. Mr. Thornton, if you have any questions, talk to your lawyer, to your attorney, Ms. Sutter, okay? All right, thank you.
Thank you, Your Honor.
You may recall your witness. Thank you. Yes.
Mr. Pfeiffer asked me to mark it. This is actually exhibit 8 according to my notes.
The 8.
8.
8-7 was a certified record. from
I
California.
apologize, forgot about the certified records.
All right.
I'm up to 8, so I marked it as
Okay. So,
I trust your numbering over mine.
Okay,
so this
thank
has
you.
been marked as People's Exhibit 8.
Yes.
All right. And Mr. Pfeiffer, you may proceed.
Thank you. The people would recall Stephanie Kraft.
And Ms. Kraft, I'll remind you, you're still under oath, okay? And ma'am, is that a yes?
Yeah.
Okay, thank you.
Appreciate it. Morning, Ms. Kraft. Now, once again, as I said last time, the purpose of today is just to get your testimonies about what you remember of these incidents. So if a question is asked and you don't remember, an answer of I don't remember is a perfectly valid answer. If we ask you about something you don't know, by that same token, I don't know is a perfectly valid answer to give. Because we're not asking you about what happened in the world, it's what you remember. Does that make sense? Okay. I'm going to keep my questioning brief, and I'm going to be putting onto the screen what's been marked as People's Proposed Exhibit 8. It's a video file by the name of Byers, and this has been shown to defense counsel previously. I'm pulling it up at the 11-minute and 30-second mark.
You haven't moved for the admission, it's just proposed at this time.
Correct, Your Honor. One moment. Ms. Kraft, can you see the television screen?
Yeah,
Do you recognize the individual in that photo?
yeah,
And is that you?
yeah.
Do you recognize what you currently are in this video?
Ambulance.
An ambulance?
Yeah.
Now, does this appear to be when you're in an ambulance with Officer Byers on April 13th, 2021?
Yes.
Does that appear to accurately reflect?
Yes.
Your Honor, at this time, I would seek to admit People's Proposed Exhibit 8 into evidence.
Any objection?
Your Honor, I don't believe there's a valid legal objection, so I don't.
Okay. Without objection, People's Exhibit 8 is admitted into evidence.
Thank you. Now, one moment. Your Honor, very briefly, I'd like to move into file 22-1852.
All right.
Ms. Kraft, on 7/13 of 2022, July 13th of this year, did you speak with police officers?
Yeah.
And did you talk about John Gates?
Yes.
And is that the same John Gates that you previously identified sitting in this courtroom? Thank you. Your Honor, at this time, people have no further questions for this witness.
Any cross-examination?
Yes, Your Honor, thank you. Good morning, Ms. Kraft.
Good morning.
I'm going to ask you a series of questions, but I want to start with the April 13th of 2021 incident. Okay.
I will try to remember when I switch to the other incident. I'll try to remember to inform you that I'm switching to the other incident. But if you ever have any questions or don't understand, please just let me know. Okay.
Okay.
Is that fair? I want to start with, like I said, this incident back in April 13th of 2021. Now, obviously, you were here previously and testified about this a little bit. Is that right?
Yes.
And I guess just to clarify, when you were here previously and were testifying the first time, you were under oath. Is that right?
Yes.
And you understand what that obligation means, correct? And you told us that you have some recollection of this incident. Is that correct?
Yes.
And you indicated in your previous testimony that back on April 13th of 2021, that you were in a vehicle that Mr. Gates was in with you, correct?
Yes.
And I think your testimony, correct me if I'm wrong here, I think your testimony was that the two of you had gotten in some sort of an argument, and during the course of that argument, he had punched you or hit you in some way, slapped you. Okay. Now, you also testified that he did not have a gun. That's correct?
Yes.
All right. And that remains your statement today?
Correct.
He did not have a gun.
No, we did not.
You never saw a gun that entire night. Is that right? Just to clarify.
I'm
All
sorry.
right. Okay. You never saw a gun in the vehicle that
No.
night. Is that right? Did you ever see a gun at the home that night?
No.
Okay. So just to clarify, you never saw Mr. Gates in possession of a firearm
That evening, no.
that evening. Now, you also originally told police officers that there was some sort of an incident in which Mr. Gates tried to grab you by the hair and shove you into the vehicle. You originally told them that. Is that right?
I don't recall. I remember there was a mutual fight.
Okay, there was a mutual fight between you and Mr. Gates, but at some point, I'm sorry.
After the initial slap.
After the initial slap. But when you were here last time, a couple of weeks ago, you testified that Mr. Gates never tried to force you back into the car, correct?
Correct.
All right. He never grabbed you by the hair, never dragged you back into
I
the
don't
car.
recall how I got back into the car. I got
Okay.
into the back seat. That's what I recall with my daughter.
Okay.
Know how.
Okay.
Yeah, I don't, it was tussle.
Okay. I think you said, and please correct me if I'm wrong here, when you were here testifying a couple weeks ago, I think you said he as in Mr. Gates, did not force you back into that vehicle. Is that
No.
your recollection?
No, I was not forced back into the vehicle.
Okay. And so if you never saw him with a firearm that evening, it would also be true that he never pointed a firearm at you. Is that right?
No, that evening, no.
Okay. And he never held you at gunpoint or
No.
forced you to do anything against your will at gunpoint. Is that right?
No.
Now, again, I believe your prior testimony was that you told the police that he had a gun when you originally called 911. Is that right?
I don't recall what I said. I was in the back of the car with my daughter's phone. They weren't responding quick enough. They weren't pinging my phone, which I thought they could do.
Okay.
To intervene in this situation.
Understood.
We did not go directly home. I was panicked at that point, and I thought I could hurry the police up and make it a priority call by saying there was a gun. That's why I did that.
Okay. All right. So I guess just to clarify, you already said this, I guess, but just to clarify, the reason for advising police of the firearm or that there may be a firearm is not because it was true, but because you were hoping that by doing so, that would speed police response.
Yes, sir.
In terms of the assault, and I'm still talking limited to the April 13th, 2021 incident now, in terms of that assault, there was some sort of a mutual fray between you and, or a mutual fight, I guess, between you and Mr. Gates that evening. Is that right?
Yeah.
All right. He never used a firearm though.
No.
And tell me about the incident in terms of the assault. He hit you the one time while you were, slapped you, I think is the term you used, while you were in the car. Is that right?
Yes.
What other, in terms of assault, what other do you remember from that evening?
I remember pulling over at Walgreens and I attempted to jump out of the car again. And he got out of the car as well, and it was a mutual fight. That's where my eye was injured.
All right, there was a mutual fight. And when you say pulling over, were you driving or was he?
He was there.
He was driving. So he pulled the car over. Is that right?
he came to a stop, I believe. He came behind Walgreens, and I think he had the stop sign there, and I attempted to jump out again.
I see. And so you jumped out of the car. He didn't force you out of the car.
No,
All right. And he got out of the car after you did?
yes, I don't recall.
That's fair. All right. There was some sort of an argument or between you and Mr. Gates once out of the car. Is that right?
At home or at Walgreens?
At Walgreens, I guess.
I was just out of control. I mean, he was trying to gain control and to calm everything down, and I was just, I was
Sure.
out of control.
Understood. And when you say he was trying to gain, he as in Mr. Gates was trying to gain control, do you mean that? Well, what do you mean by that?
Well, there was a cop across the street,
Okay.
and my idea was to, flag the cop down or whatever, and his idea was, let's go home, calm down.
I see. All right. But you returned to the vehicle voluntarily at that point?
I was in the passenger seat, and then somehow I ended up in the driver's side rear is where I was sitting. I don't know how I got back in the car. It was 2 years ago. I don't recall.
Understood.
I
You
know I
don't,
was sitting in the back seat, so I got in there. He didn't force me in the car though. My daughter was in there, was getting in there to protect her, to shield her.
I see.
from
All
all
right.
this.
So just to clarify, he did not force you back into that vehicle.
No,
Was there any further assault that took place at all that evening?
threats, but
Threats?
the assault was done. He
All
was
right.
just trying to get me to come back inside. When we got home to my home, he was inside and I was still outside flailing and being crazy, and
Okay.
he's trying to get me to come back inside.
All right. Now, when you say he was trying to get you to come back inside, do you mean that he physically grabbed you and
No, he
tried
was
to?
standing at the door. I was out the road.
All right, so he was asking you to come back inside at this point? Or telling
me.
you? Did he threaten force if you didn't come back in the house?
I don't recall.
All right. And eventually you came back in the house, is that right?
Yes,
All right, and you came back in the house on your own free will, is that right?
I did.
Okay. Was there any further physical assault inside the house after you returned?
Physical. Came back inside. I don't recall. I remember him leaving. I remember him standing at the door.
You remember him leaving, as in Mr. Gates left the house?
Yeah, I was in my daughter's bedroom trying to comfort her.
Okay. And if you need a minute, that's totally fine. Just let me know. I'm happy to give you all the time you need, okay?
Okay.
Now I want to turn to the incident, the more, I guess, recent incident. This is going to be the incident of July 13th of this year. On that date, tell me about was there an argument on that date between you and Mr. Gates?
Probably between myself and I.
Between yourself and I, is that what
I
you said?
came home mad, yeah.
You came home mad. When you say you came home mad,
John
where-
came here to turn himself in on the first charges.
John, being Mr. Gates,
Mr. Gates.
flew here.
left On July 1st
Okay,
to turn himself in,
okay,
so we could get that case, in this case, behind us. And
okay. And so he flew here, and while he was, you said he flew here on July 1st.
Correct.
And this incident is supposedly on July 13th, is that right?
Correct.
All right. Did you call the police?
John called the police. Mr.
John-
Gates called the police.
Mr. Gates called the police. If you know, why did he call the police?
I was threatening to call the police. I dialed like 9 and he pushed 11 and son. Because I wanted to get it behind us, but he wanted to have an attorney prior to turning himself in.
Okay, so excuse me, let me break that down. You wanted him to just go down and turn himself in, is that right? just turn himself into the jail to take care of the,
I wanted to
older
meet
man.
with an attorney and then, yeah,
and he was, at least your understanding was he was hesitant to do that without having an attorney in place
Correct.
first. Was there a physical altercation on that day?
I went outside when the police were called. I had went outside, I had came back inside and he grabbed me. It wasn't, I wasn't assaulted. He did grab me, but it was, again, it's just us fighting, a realization he's going to jail now. Get your stuff.
Okay. I'm sorry, I didn't mean to cut you off. Were you finished? Were you finished?
No, go ahead.
Okay. When you say that he grabbed you, describe that for me. How did he grab you?
He came up behind me and grabbed me.
Grabbed you by your shoulders, by your hair, by your waist?
Yeah, he went to pick me up, I think.
To pick you up.
Right.
So he was behind you and he's grabbing you. Is that now when you say he's picking you up, you mean behind by your waist with his
He was
arm?
behind me, so I don't know what he was doing. He came from behind me and picked me up.
Pick
Was
you up.
threatening to choke me. There was no assault there. There shouldn't have been charges that day. It was.
Objection, Your Honor. The victim is not testifying as to a legal conclusion as opposed to what actually happened that day.
The objection sustained, however, I'm only hearing the facts of it. I know she can't indicate what an assault is or what an assault is not. So objection sustained. You can continue.
Thank you, Judge.
Ms. Kraft, let me ask it this way. When Mr. Gates came up behind you and picked you up, did you feel scared? Did Mr. Gates specifically threaten you?
No.
No, he did not threaten you. Did he physically injure you in any way?
No.
Did he physically punch you, kick you, hit you, bite you,
No.
choke you?
I think that's what he was trying to do.
You think that's what he was trying to do?
Yeah.
Tell me about that. What is it that
He
he
went to
did?
grab me from behind.
All right. Now,
I fought him off.
all right, when you say he grabbed you from behind, did he grab you? You felt his hands on you?
Yeah.
On your neck, on your shoulders, on your waist?
Right here. He went to grab me and pick me up.
And let the record reflect that the witness has indicated, do it again, ma'am.
He was behind me, so I don't know what his motions are. I just remember him picking me up and me going towards the ceiling, but I was.
All right, so
waiting
let
for-
the record reflect that the witness has raised her arms and indicated that she felt like he was trying to pick her up.
Yeah, she indicated the shoulder region
Okay.
Yeah, I think that's a fair assessment.
or underarms.
Yeah,
Yeah.
and I was going to clarify that. Just, I want to be clear. When you say he grabbed you, you've indicated that he grabbed you in your shoulder area, but was that over your shoulders or were the hands
I
underneath
think
your
he went to
armpits?
try to do that and then just ended up grabbing me up here. Yeah.
Under your
I mean,
armpits?
he was trying to choke me, okay,
Uh-huh.
and he didn't, and he grabbed me and I ended up towards the ceiling and I'm flailing, fighting
And he-
off, and that was it.
Got it. And he picked you up by under your arm. He picked you up at some point. What happened once he picked you up?
I don't remember, I just remember screaming, I don't know, I was screaming, I went outside, I don't know. We were yelling at each other.
So presumably at some point he put you back down.
Yeah.
obviously. All right. And if you recall, was there any further contact, physical contact between you and
No.
Mr. Gates once he set you back down?
No.
And then you said you went outside.
Yeah, I knew the police were coming.
All right. And the police were coming because Mr. Gates had already called them.
Yeah.
Now it's okay. Now I just want to clarify, you had indicated that originally you were going to call the police, right?
I was threatening, because he was playing a video game and I was annoyed by that.
All right. So in threatening to call them, you were going to call them to, your intention was to call them to turn Mr. Gates in on the
I
warrant.
wasn't gonna call the police that day.
Okay, you
I
were
was
set.
threatening.
Got it. All
I
right.
just wanted to put a fire under his butt and say, you gotta.
Gotcha.
Okay,
So,
that's-
so it was a threat, but with, at least as far as you were concerned, no actual intention to do that. And then he is the one who ultimately called the police. Is that right?
Yeah.
Thank you, Your Honor. I have no further questions.
Can you redirect?
Yes, Your Honor. I want to go back to the 2021 incident. Now, you testified on cross-examination here. When you were asked if he pulled a gun on you, and I said, if he had pulled a gun, you said, no, he didn't do it on that night. Has he ever pulled a gun on you?
No.
Has he ever talked to you about this incident and whose fault it is? And what did he say? To the best that you can remember,
What did he say about the incident?
and whose fault it was.
Mine, I was in trouble.
Has he ever talked to you about what you should say in court about the incident?
We have talked about. I sound like a victim stating that, this is my fault and blah, blah, blah. Listen, I was part of this.
I just want you to, and I, no, but just want you to answer that question.
Okay.
Did he talk to you about what you should say in court?
We've discussed it before.
And did he say that you should tell the court you were the one who started it?
Yes.
Do you remember for the 2022 incident, more recent one, last month, do you remember that on July 13th, you told officers that you were having pain in your throat?
Yeah.
Do you remember if you had a scratch on your neck?
Yes.
Now, you said that you were just threatening to call 911. You were actually going to call police, but he believed you were going to, right? I mean, you'd already dialed 911.
I got a 9. I have my phone like this and walked over.
That was the point of threatening, is to make him believe that you're going to.
I don't know what I was, probably, I don't know what I was thinking. Just wanted out of the situation.
Okay.
Over with.
One moment. Now, you said that you have some recollection of these incidents.
Yes.
Is it difficult to remember exactly what happened on these days?
Yes.
And is there a specific reason for that?
A relationship was just one big fight.
About how long was it going on for?
2 years. Yeah.
And there were other physical altercations?
Other than these nights.
Other than these 2 nights?
Yes.
Thank you. Your Honor, at this time, people have no further questions from this witness.
May any objection to this witness being excused from the people?
Not from the people.
Mr. Palmer?
No.
All right, this witness is excused. People can call their next witness.
Your Honor, people have no further witnesses at this time.
All right, people rest.
I'd ask for a brief, assuming the defense is done, a brief 5 minutes.
All right, and does the defense have any proofs today? All right, so we'll take a 5-minute adjournment, and then we'll have the bind over motion.
That was not testimony that was under oath. She's admitted that she lied in those statements. I would suggest to the court that her testimony under oath is much more credible than the statements given at the original time. I would ask that the court to dismiss.
Your Honor.
Response?
Yes, briefly, Your Honor. First of all, each and every time she's asked about what happened in a certain incident, such as how she got into the house, how she got to the car, whether something happened inside the house, she's cried. I don't remember. I can't recall. And then when asked again and given the opportunity to further minimize what happened, she then took the opportunity to say, I don't remember what happened. I just don't remember. Well, did he assault you at all? Oh, no, definitely not. Will he drag him to that house? Oh, no, definitely not. She's having a difficulty remembering what's happening, except when she's given the opportunity to minimize what he did, which goes exactly into what I was saying earlier, thanks to the coaching by Mr. Gates. And there's something I'd like to quote. It is from the Michigan legislature. Because of the repetitive nature of domestic violence and the offender's ability to continue to manipulate the victims, rules of evidence regarding past actions and hearsay restrictions should not apply in domestic violence cases. To hold batters accountable for their actions, the law should allow prosecutors to highlight ongoing violence as part of a large screen. Similarly, when a victim makes a statement about a domestic abuse incident to police, but later recants or refuses to appear in court, the testimony of the law enforcement officer regarding the statement made to him or her should be admissible. Otherwise, an offender, through his or her control over the victim, may have the power to determine what evidence is or is not presented to the jury. That was the Michigan legislature when they were arguing the passage of MCL 768-27B and 27C. This is quite literally one of the exact situations that 27C and 27B are designed for. The defendant, even while prosecution is continuing, is able to exert control over the victim. And as a result, just through the fear alone in domestic violence cases, the victim either does not appear to testify or recants at court. That's the entire purpose that 27C exists. It is clear from her testimony and what she told the officers on those days, the evidence that was admitted under MCL 768-27C is more credible than her direct testimony today. She didn't tell the officers she didn't remember what happened. She didn't tell the officers that, oh, well, it was all, a lot happened. She knew exactly what happened when she talked to those officers in each of those incidents, because it just happened. And Mr. Gates hadn't had the time to tell her what happened and whose fault it was. There's photographic evidence backing up what she told the officers. I believe it's clear, Your Honor, as to what actually happened that day. And I'd ask that you find that there is a probable cause standard burden of proof that has been met for each of these counts.
Thank you, counsel. First of all, the standard is probable cause. It's preliminary examination. So it's the second lowest standard. Probable cause to believe a crime has been committed. Probable cause to believe that the offense was committed by the defendant. The probable cause standard in this instance, over 2 sessions, I don't believe we have an argument in this file, which is 21-01010, concerning the location, which is Joliet Cedar, City of Lansing, Ingham County, State of Michigan. The venue, which is in State of Michigan, City of Lansing, Ingham County. Identification of the individual involved, and date, which is on April 13, 2021. So now we're down to the counts and the offense. And in this case, there were Ms. Kraft testified. Her testimony is anything but clear. Also, the officers testified in this matter. And something that really indicates for this bench in regards to the probable cause level is there are exhibits in this file. Okay, there are also not exhibits in this file. There's also testimony that is not corroborated in this file. And so I'm going to take all that into account when I go through each count. So as to count one of unlawful imprisonment, I find that the people have not met their burden by probable cause evidence. I find that the testimony is certainly unclear regarding the elements of that crime, which are unlawful imprisonment, that the defendant knowingly restrained another person. Restrain means to forcibly restrict a person's movement or to forcibly confine the person as to interfere with that person's liberty without that person's consent or without lawful authority. The restraint does not have to exist for any particular length of time, may be related or incidental to the commission of the other criminal acts. Second, that it would involve a dangerous weapon, which we'll talk about later, and the person was secretly confined, which means a keep or keeps the confinement or location of the person secret. That doesn't appear to apply in this case. The person was restrained to facilitate the commission of another felony or to facilitate flight after the commission of another felony. There's conflicting testimony concerning the actual testimony that was indicated once a lawyer came in and read and understood what the witness was indicating and the consequences of the witness testimony. There's definitely conflicting testimony in this problematic witness for this case. I do not find that the people have met their burden of proof by a probable cause standard as to count one, unlawful imprisonment. So that count one is dismissed at this time. Count two, assault with intent to do great bodily harm, less than murder. I do find that there was not only evidence from the witness that there was a fray involved in this matter, not only that there was evidence from corroborating evidence from the testimony concerning the fray, and then exhibits 1, 2, 3, 4, and 5, and 6 all indicate, along with testimony from the victim, physical evidence, and then what the victim indicated to the officer, which has now been corroborated, that there is probable cause evidence to believe that the defendant did make an assault upon Stephanie Kraft with intent to do great bodily harm less than the crime of murder. That is count two, a felony. There is probable cause to believe that that crime has been committed, that the defendant committed that crime. I will bind over on count two. Counts 3, 4, 5, 6, and 7 all indicate 3 through 7 that there was a firearm used in this event. Other than the initial statement made and the explanation made to the police as to why Ms. Kraft indicated there was a firearm, there is no other evidence to suggest that there's a firearm present. There's no photographs of the firearm. There's no firearm present in regards to law enforcement who was at the scene. Therefore, I'm going to dismiss counts 3, 4, 5, 6, and 7 as the standard has not been met by a probable cause, and counts 3 through 7 are dismissed as the people have not met their burden in that regard. The added count 8, I look at the same as added count as count 1. I don't believe that criminal intent can be inferred by the conduct that was indicated to law enforcement once it's been retracted, recanted, and indicated that never happened by the victim, and the victim was subject to counsel and counseled as to the consequences of their testimony. I'm not willing to infer the spaces in between regarding that testimony. And so I'm not going to bind over on count 8 in regards to this felony complaint. Count 9, domestic assault. I think we have plenty of evidence. I don't have to address that. That'll follow count 2 in regards to circuit court. So I find probable cause for count 2. The other counts are dismissed, and the final count of count 9 will follow. If that's a misdemeanor, will follow count 2 in regards to 21-01010. Now, as to file 22-01852, do the people want to make a motion as to bind over on that second date?
Yes, Your Honor.
You may proceed.
Once again, Your Honor, I'll continue all of the arguments I made beforehand as to the credibility of victim testimony, particularly here. She told the officer that day that he strangled her, grabbed her around the neck. She told the officer that her throat hurts, complaining about she had difficulty breathing when this happened. And I think most importantly, the officers themselves personally observed injury to the neck. They observed scratch marks on the neck, which, as the officer testified, is indicative, not indicative, was in line with a strangulation having occurred. And given that she said consistently through her testimony she had difficulty remembering what happened, I would ask that you look to the 27C evidence. Again, as I quoted from the Michigan legislature, part of the reason that exists is for victims of difficulty remembering or recant. So I believe that there has been a probable cause standard met for count 1, assault with intent to great bodily harm less than murder or by strangulation. I would also ask for an added count 2, interfering with a crime report by committing a crime, threatening to kill or injure. The PAC code for that is 750.483A2B. Ms. Kraft was going to call police and have him be arrested. She told him as much. She had started dialing 911. She says, oh, she didn't actually mean to, it was a threat, but that doesn't matter. What matters, what Mr. Gates did. Mr. Gates believed this individual was calling the police to report that he had committed crimes. And he stopped her by grabbing her by the neck and lifting her off the ground. He interfered with a crime report by committing a crime, that crime being assault by strangulation. Afterwards, he dropped her. And then he hit one and he said, now you have something to tell them. But the fact that he eventually finished that call to police does not mean he did not commit this crime. Because in that moment, he was stopping her from calling police. He was intending to stop her from calling police. The fact that he changed his mind after he strangled her doesn't matter. Because it's intent in that moment. It's clear why he didn't. He didn't wait for her to finish dialing. I'd also ask for an added count 3. Police officer assaulting, resisting, or obstructing. PAC code for that being 750.81D1. As Officer Stacy Myers, who identified the defendant, told him, stop, don't go in there. Stop what you're doing now. The defendant looked over, saw her as an officer in full uniform, in broad daylight, telling him to stop. Don't go into that house. They went into the house. I'd ask that you bind over on that add count 3. And then finally, requested add count 4, that being misdemeanor domestic violence. PAC code for that being 750.812. I believe the probable cause standard has been met for each of those charges and ask that you bind over as requested.
Response? Excuse me. Thank you again, Your Honor. Just to be clear, I will start out by saying Mr. Pfeiffer's requested count 4 again is misdemeanor. I'm not going to address it. It's not before the court today, so I will leave that to court's discretion, I guess. I'll put it that. With regards to count 1, again, Judge, I'm asking the court to dismiss for lack of probable cause. The testimony we heard again from Ms. Kraft was a little confusing in this regard. Her testimony was, and I guess we all saw it, but her testimony was that Mr. Gates had approached her from behind, that he grabbed her, and this was a little inconsistent, I guess is the best way I would put it, but he supposedly grabbed her from behind. She indicated that she couldn't see exactly what he's doing, of course, because he was behind her, but she indicated originally that the grabbing, I guess, was in the neighborhood of the shoulders, and I think that's how we all agreed to describe that. Then she later said that the testimony, or that her later testimony was that the grabbing was, I guess, under her armpits. In other words, the hands came through under her armpits and lifted her off the ground. Now, Your Honor, that I guess could potentially be an assault. It could be a harmful or offensive touching, but that is not assault by strangulation. That is, for assault by strangulation, there has to be some indication that he attempted to, in some way, restrict her airflow, that he attempted to cause her to stop breathing. He did some manner to prevent that airflow. We did not hear any testimony regarding that. Again, like the previous case, I acknowledge that there was other testimony from officers regarding her statements that were given on the date of the incident on July 13th. But again, Your Honor, she has chosen to avail herself to the court today. She's here. She's testified under oath. She confirmed that she understands what the penalty of perjury is. And nonetheless, she's not provided testimony that would support a strangulation. She's provided testimony that I think at best says that he lifted her off the ground. So I would again ask that count 1 be dismissed for lack of probable cause. With regards to count 2, the interfering with the crime report, again, I will point to Ms. Gates's own testimony here, which is that there was some sort of I think, and please don't quote me on this, but I think her testimony, because we've heard it over a couple of days, was that there was an argument between Mr. Gates and Ms. Kraft that she was frustrated with him because I guess there was some issue about him trying to turn himself in on the original case. She was frustrated and she threatened to call the police. And her testimony here was that she dialed the 9 and Mr. Gates walked over and dialed the 11 and completed the call. He didn't interfere with the phone call. In fact, he completed the phone call. The issue that we have now is that from Ms. Kraft's testimony, it is again unclear in terms of where in time these two events occurred between the alleged strangulation, which is in count 1, and this interfering that is in count 2. In other words, I'm not sure that there's anything to suggest in the record that somehow she dialed 9, that he walked over, committed this alleged assault, preventing her from doing the 11, and then completed the call. So in other words, my point is, I don't know that there's anything specific here that says that he in any way interfered with her writing or reporting a crime. So I would ask that that matter be dismissed. With regards to the resist and obstruct matter, Your Honor, that is admittedly probably a question of fact. The testimony we heard was that the officer was outside near the house, that she saw Mr. Gates outside, that she ordered him to stop, that he returned inside the house. Then he came back out, I think several minutes later or some short time thereafter, at which point he became compliant and cuffed up. I think there is a question as to whether Mr. Gates ever heard the initial commands or ever actually realized that the officer was there. I believe, but because it was 2 weeks ago, I don't know for sure. I think that the testimony she provided was that when she originally told him to stop, he took no action and acted as if he ignored her. I guess it is at least possible that he never heard that command initially and then complied. Again, Your Honor, I will acknowledge that is probably a question of fact, which is not to be decided by this court. I will, I guess, for the sake of argument, ask that the court dismiss that matter for lack of probable cause too, but certainly with the acknowledgements. That is my argument on those matters today, Your Honor. Thank you.
Thank you. Response?
First of all, Your Honor, testimony from the officer is that when she shot for him to stop, before going into the house, she told him don't go into the house, he turned around, looked over his shoulder, and looked at the officer. The officer told him, don't go into the house, and then he went into the house. It was only, I think it was 5-10 minutes later that he came out of the house. So that was the testimony from 2 weeks ago. Secondly, Mr. Palmer says that there is no testimony indicating that she started dialing the 9 and then he attacked her, stopping her. Yes, there was, from the officers. The testimony from 76827C is not impeachment evidence. It isn't anything to go to trust grants. It is substantive evidence. The testimony that is introduced into evidence under 27C is substantive. And while it conflicts with the victim said here today, the victim also said she had a hard time remembering what happened on this date. Consistently. She was consistently having trouble remembering what happened. She was consistently minimizing what happened. And again, saying that when he came up behind her and, quote, tried to choke her, unquote, that was just them mutually fighting and having a tussle. That's how she described it. She didn't just say, well, he grabbed me on her. She said he was trying to choke me. But even then, she still said she had trouble remembering what happened. She was consistent with the officers. She was clear with the officers, which is why 27C exists, for exactly these situations. And with that conflicting testimony, that's a matter of fact for the jury to find, or a fact finder. I'd ask that you bind over his charge and find there's a probable cause burden that has been met, because 27C is substantive evidence. Thank you.
Okay, in regards to file 22-01852, it's once again a probable cause standard. Probable cause to believe that the crime has been committed. Probable cause to believe that the defendant, the identity of the person who committed the crime. As to count one, I don't think there's any argument concerning that this all occurred on July 13, 2022 at 4914 Star Avenue, City of Lansing, Ingham County, State of Michigan. That's the date the defendant was identified as John Levon Gates by witnesses. Count one is has some conflicting testimony based on what was told at the scene and later told under oath, subject to consequences, subject to the consequences involved in with getting an attorney and recognizing the rights of the individual. There is other testimony that is not hearsay testimony. I understand that that the statute provides for the admissibility of substantive evidence, and that's what's happened. It's been admissible. Now we weigh it, and we weigh that evidence, and it's part of the weighing of the court. I do find that the testimony concerning marks on the victim by the officer indicating that there's physical harm done by the throat and the chest area to the victim, and they are not old bruises as was testified, they're new bruises, corroborates not only the statement made at the scene by the victim, but also somewhat what the victim indicated under oath, that they were essentially grabbed and scared from behind. And then there's testimony that they were lifted up. They indicated they were scared and grabbed from behind, and that they felt that and this is an inference on their part, but they did feel that the intent was to suffocate them. And that was said on the stand today. It's not what was said at the scene. What was seen at the scene was the hearsay testimony that they were actually strangled at the scene. I find there's probable cause evidence to believe in count one that did make an assault upon Stephanie Kraft by strangulation or suffocation. That felony is met by the prosecutor by probable cause evidence and is bound over to circuit court. As to count two, much harder, much more questionable concerning the interference based on the testimony and then the contrasting testimony under oath. I do not find there's probable cause to bind over on count two interference with a device in order to prevent or to report a crime. So count two is dismissed as requested. Count three is problematic. It comes from the officer. It comes from, and I've looked up the statute specifically because it's generally not this type of resisting and obstructing is definitely a little different than the normal. The police officer was in uniform. There doesn't seem to be any dispute that they were performing their duties in an investigation. Obstruct under the statute does include knowing failure to comply with a lawful command. The defendant must have actually resisted, but physical violence is not necessary. I do believe that counsel is correct. It is a statement of fact for the jury to decide. There is contradicting testimony. However, the officer indicated that the person did knowingly obstruct by entering. The defendant did knowingly obstruct by entering into the residence, and therefore there's probable cause evidence to believe that the crime was committed and the identity of the person is the defendant who committed that crime. I will bind over on the added count three, but it's now count two, added count three of resisting and obstructing. A count for domestic assault will follow as a misdemeanor as requested. I do think it's part of the file and it's now, so I will bind over on counts 1 and 3. Count 4 will follow as a misdemeanor. Count 2 is dismissed. Anything else? So those counts are bound over to circuit court in order for the defendant to stand trial on. Anything else for the record in docket 22-01852 from the people?
Real quick, I want to clarify the numbering of counts that were bound over.
Yeah, that's probably a good idea.
So count 1 is the assault strangulation.
Yes.
Count 2 is the police officer ARO.
Yes, the resisting obstructing would be count 2,
Then
and count 3 would be the domestic assault.
Perfect.
Right. Anything else on the record in docket 22-01852, Mr. Pfeiffer?
Not from the people.
Anything from the defense?
Your Honor, just simply that my client has just asked me to address the bond.
You may.
Your Honor, I would ask that the court consider a bond reduction. I do realize that I will simply put it this way. I recognize that my client has a criminal history. I certainly am not going to try to debate that, but I will note for the court that in both files, charges have been significantly reduced, at least to some extent, or requested counts have not been added. I believe, Your Honor, that he is entitled to a bond reduction in that regard. I certainly believe that Mr. Gates, if released or if able to post bond, it could be monitored by some other method of such as a GPS tether as opposed to being in custody. I would simply ask that the court consider a reduction of bond at this time.
Any response, Mr. Pfeiffer?
In addition to the arguments I made last week about him trying to call the victim a bunch, telling family he's going to flee, he'll never step foot in Michigan again because it's an entrapment state. His criminal history is a massive criminal history. There's sexual assault, there's guns, there's drugs, there's physical violence, and also numerous times that he has been paroled and then violated said parole. He literally left the state, came back, said he's going to turn himself in, was with the victim for 2 weeks, and then when she went to actually call the police, assaulted her again. And then refused to follow the officer's orders. And I would also note, we heard on the stand that while that case was pending, he was telling the victim, no, you're the one whose fault it was, you're the one who started it. Tell the court this happened. He will absolutely do that again if released and his bond is lowered. And I doubt we'll see him again because he said as much. So I'd ask that you keep bond where it is.
Bond was set by the Judge DeLuca, in the amount of $500,000 cash or surety. There have been reduced counts in regards to this. However, none of the assaultive counts were reduced in this matter. And quite frankly, the court didn't feel any better about the 2 files and the safety of the community and the safety of the victim after the testimony. I'm going to leave the bond at the same. $500,000 cash surety is file 21-01010 and file 22-01852. The bond will be left the same at $100,000 cash surety. The request for bond is denied at this point. You can revisit in circuit court, I assume.
Understood, Your Honor.
Thank you, guys.
So that's all for the record in these 2 files. On the record in docket 22-01979, that's people of the state of Michigan versus Kevin B. Nemeth. Will the parties please introduce themselves for the record?
Thank you. Good morning, Your Honor. Erin Housefield on behalf of the people.
And Assistant Public Defender Scott Nickel on behalf of Mr. Nemeth, who is present and standing to my right.
And sir, you are Kevin B. Nemeth?
Yes, Your Honor.
All right. This is the time set for a preliminary examination. Ms. Housefield, how are we proceeding today?
Thank you, Your Honor. It's my understanding that the defendant wishes to unconditionally waive his right to hold the preliminary examination. The people also unconditionally waive their right to the examination and ask that the matter be bound over to the circuit court on the complaint as filed. There are no specific offers at this time, but negotiations will continue at the circuit court.
Is that a correct statement, Mr. Nichols?
That is, Your Honor.
May I inquire of your client?
You may.
Mr. Nemeth, you understand you have a right to a preliminary examination in this file.
Yes, Your Honor.
And that preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime's been committed and probable cause evidence of the identity of the person who committed that crime, correct?
Yes, sir.
And you understand that. And if you waive your right to a preliminary examination, you'll leave this district court, you'll go to circuit court, where it'll be handled in a different matter as in a different court for trial in that court. Do you understand that?
Yes, sir.
Okay. And you're represented by counsel, Mr. Nickel. And of course, if you had that probable cause hearing, you'd have the right to have Mr. Nickel cross-examine any witness and contest any charges in this matter. Do you understand that?
Yes, sir.
It's my understanding it is your wish today to waive your right to a preliminary examination and have this case go forward in circuit court.
Yes, sir.
All right. I find the waiver of the preliminary examination to be freely understanding and voluntarily waiver. My understanding is that negotiations are to continue in circuit court.
Yes.
The prosecutor also waives their right to a preliminary examination. Anything else for the record in docket 22-01979, Ms. Housefield?
No, thank you.
Anything, Mr. Nichols?
No, Your Honor.
All right. Keep in contact with Mr. Nichols and he will give you the next date of arraignment in circuit court. All right, sir?
All right.
All right. Thank you. You're all set.
Have a good day.
You too.
Mr. Nickel?
Yep.
I'll need you to sign the waiver, please.
Are the people ready to proceed with their first witness?
Yes, Your Honor.
You may proceed.
I will be calling Officer Matthew Stevens to the stand, Your Honor.
Right, officer, I'm going to have you come right this way. And right in front here, I'm going to have you state your first name and spell your last name for the record for the court reporter.
My first name is Matthew. My last name is Stevens. That's spelled Stevens.
Hey, raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under the penalty of perjury?
I swear.
All right, you can have a seat. That microphone is for auditory purposes, is not for recording, so speak as loud as you can. And Mr. Wisty, you may proceed.
Thank you, Your Honor. Officer Stevens, where are you employed?
The City of Lansing Police Department.
And how long have you been in that position? What's your position there?
As a police officer.
How long have you been in that position?
Roughly 1.5 years.
In the capacity of your employment, were you involved in an incident that happened on July 26, 2022 on Long Boulevard in Lansing, Michigan?
Yes, sir.
And Lansing, Michigan is in what county?
Ingham County.
During that incident, did you come in contact with a Kenneth Jones?
Yes, sir.
Do you recognize Mr. Jones in the courtroom today?
Yes, sir.
Could you point him out and identify something he's wearing?
Over there. It's wearing the black shirt there.
May the record reflect the defendant as identified. Record reflect the witness as identified the defendant.
Any objection to
No
identification? Okay, without objection, the witness has identified the defendant.
And what brought you to that location that day?
So we received a dispatch call from someone that resides at the address at apartment 321, 900 Long Boulevard. Saying there was some form of altercation that occurred and that the accused possibly needed medical assistance.
When you arrived at the scene, what did you do?
When I arrived at the scene, we observed blood on the porch and on the doorway. So we knocked on the door, announced ourselves, and tried to make contact with residents inside.
Did you come in contact with Melania Moore?
Yes, sir.
Your Honor, at this point, I will be attempting to elicit hearsay testimony admissible pursuant to MCL 768.27C. I would be asking to ask a series of foundational questions here.
Okay, yes, I'll allow you to ask the foundational questions. I'll only ask you to speak up for the court reporter.
Thank you. So when you came in contact with Melina Moore, correct?
Yes, sir.
Did she report to you? What did she talk to you about an incident? And what did she talk to you about generally?
About
Objection, Judge, lack of foundation.
Your Honor, what I'm doing, I believe I need to establish this foundation. I'm asking these pursuant to foundational questions.
Objections overruled.
What did she talk to you about generally?
So she spoke about an assault that occurred prior to our arrival.
Did she give you an idea when that occurred?
Approximately 20 to 30 minutes prior to our arrival.
At this point, were you in your uniform?
Yes, sir.
Did you identify yourself as a police officer?
Yes, sir.
Did she tell you what a relationship was with Kenneth Jones?
Yes, sir.
What was that relationship?
About a dating relationship for approximately 3 years. They have one child in common.
Your Honor, I believe that satisfies the element or the statutory requirements for hearsay testimony pursuant to the statute.
I agree. Any objection on in regards to the hearsay testimony coming in?
I would object based on the confrontation clause, Your Honor. I know and I am aware of the Michigan case law that's against it. However, I still believe that I need to object on the constitutional basis.
All right, thank you. The objection is overruled and you may continue.
Thank you, Your Honor. What did Ms. Moore tell you about what had happened earlier that day?
She had stated that she was inside the living room, sitting there with her daughter. She heard a noise coming from upstairs, believed it to be Mr. Kenneth Jones. Juania walked upstairs to investigate what it was. She came up there, she saw that Kenneth was finagling with a jar of change. He said he was going to take some of the money and go purchase some more alcohol.
Did she confront him regarding that?
Yes, sir.
What happened when she did that?
When she confronted him, Kenneth had pushed her against the door in the bedroom upstairs.
What happened from there?
Kenneth then proceeded to punch the door, leaving a hole inside the door, and then as well punch the wall in the bedroom, leaving a hole there as well.
And after that happened, did anybody else become involved?
Yes, Juania's daughter, Lelania, she came upstairs and was trying to figure out what was happening.
And what happened when she appeared on the scene?
When Lelania came upstairs, Kenneth had grabbed her by her hair and began to punch her face before throwing her onto the ground.
And after he struck Lelania, did he turn back to Miss Morgan capacity?
Yes, sir.
What happened then?
So Kenneth had then pushed Miss Moenia back, hold her back.
And what happened from that point?
After that altercation occurred upstairs, Kenneth had ran downstairs to separate himself from the two that were upstairs in the bedroom.
And what happened from that point in time?
From there, Moenia went downstairs to confront Kenneth, stop him from leaving, and more so to check his welfare, figure out why he did any of this. At that point in time, Lelania was shortly behind her. But prior to Lelania arriving downstairs, Kenneth had punched Moenia in the face.
So there's one confrontation that occurs mainly upstairs, is that correct?
Yes.
You're gonna have to raise your voice.
Okay, there's one confrontation that includes mainly upstairs, correct?
Yes.
And then there's another confrontation going on downstairs?
Yes, sir.
And what are the details of the one downstairs?
So downstairs is when Kenneth was attempting to flee the house, but Moenia wanted to confront him about it and ask him why he would assault them in the first place.
And what did he do at that point?
Kenneth proceeded to strike Moenia first in the head with his closed fist. Preceding that, Lelania tried to step in once again and prevent any further altercation happening between the two. Kenneth once again grabbed onto Lelania's hair and began to strike her once again. And then between that, Moenia tried to separate the two, but due to her being unable to, she saw an object on the ground near the front door. She picked up the object. The object was a chrome.
And who is she? Is this, are you referring to Liana or Moenia?
Moenia. So Moenia saw this object on the ground. It was a chrome tire iron. She picked it up and she swung it at Mr. Kenneth Jones to get Kenneth off of Lelania. It hit Kenneth in the left side of his forehead. And then that caused them to separate.
And then when you arrived on the scene, was Kenneth still there?
No, he was gone.
And then again, can you tell me what Moenia said the relationship between her and Kenneth was?
Dating relationship, approximately 3 years, in one Sheldon County.
Did she tell you where they were living?
They were living at 900 Long Boulevard, apartment 321.
Were they living together?
Yes, sir.
And then in the course of your investigation, did you also interview Liliana Christina Michelle Milton?
Yes, sir.
Your Honor, I would Move to elicit hearsay testimony pursuant to the statute here. I believe the elements have already been established by prior testimony as regards to Liana.
Response?
Your Honor, I don't believe that it has been established. I believe so there are some foundational elements that still have to be met.
Okay, do you have an argument as to those foundational elements?
Yeah, I don't believe that there has been any sort of residential establishment regarding Lilani.
May I ask a quick follow-up
You
question?
can ask a quick follow-up question in regards to the objection.
Did Ms. Moore tell you where Liani resided
Yes, sir.
and where did she reside?
At 900 Long Boulevard, apartment 321.
Your Honor, I believe that's done that testimony that element is met.
Any objection? I know you made your confrontation objection, which has been noted. Any other objection?
No, Your Honor.
Okay, so the objection's overruled as a confrontation. I believe foundation's been laid for the statute. You may proceed.
Thank you, Your Honor. When you spoke to Liana, did she tell you how old she was?
Approximately 13 years old.
And that's your recollection? She said she's approximately 13 years old.
She is 13 years old, yes.
Okay, she knew how old she was.
What's that?
She knew how old she was.
Yes.
Okay. And can you go over what did she tell you that happened between the confrontation between Mr. Jones and her?
She had advised me that she was also sitting downstairs in the living room with her mother when her mother went upstairs to investigate what the sound was coming from the bedroom. Lilani, or Lilania, she stated that she heard some kind of noise, almost like someone hitting a wall upstairs. So she went to investigate. When she went upstairs, she saw that Kenneth Jones was on top of Lania.
What did she do at that point?
She attempted to break both of them up, stop any further altercation from occurring. But at that point in time, Kenneth Jones had grabbed onto her.
From there, what happened?
Kenneth proceeded to punch Lilania's face multiple times while holding her hair.
And then the remainder of the statements Liana told you, were they consistent with Moina's testimony?
Yes, sir.
Any inconsistencies between what she told you or what the two parties told you?
No, sir.
Your Honor, I don't have any further questions.
Cross-examination, Ms. Robinson.
Yes, Your Honor. So, Mr. Stevens, you testified that you did come into contact with Mr. Jones that day.
Yes, sir. Yes, ma'am.
And can you describe how Mr. Jones looked?
So when I saw him, it was at Sparrow Hospital. Mr. Jones had a wound on the left side of his forehead from where he was struck by the object.
Okay. And when you say wound, can you describe the wound?
It was almost like a laceration on the left side of his forehead, approximately 1 to 2 inches long.
Okay. And there was blood all over his face, would be fair to say, correct?
Yes, ma'am.
Okay. Do you notice any other, you probably did notice other marks on Mr. Jones then, correct, as
Yes,
well?
ma'am.
Besides the marks on his face? You noticed some bite marks on Mr. Jones, correct?
Yes, ma'am.
Okay. And those were on his torso area?
It was on his left thigh.
Oh, left thigh, excuse me. Okay, so you observed some bite marks on his left thigh. And at any time when interviewing Moenia or Lilania, did they tell you about any sort of bite marks?
Moenia did.
Moenia did. Okay, did you include that in your report?
No, ma'am, I did not.
Okay, and you would consider that to be a crucial piece of evidence, wouldn't you?
Yes, ma'am.
Okay, and as an officer who's been doing this for 1.5 years, you're trained on how to write a complete report, correct?
Yes, ma'am.
But you didn't put this in your report.
Yes, ma'am.
All right, and did you talk to Mr. Jones at all that day?
At the hospital, but nothing in relation to the crime itself.
Okay. At the scene of the incident, did you notice any blood on Moenia?
On Moenia, yes, I did.
And where exactly did you notice blood on her?
It was on her right arm as well as the right side of her face.
Did you take pictures of Moenia that day?
Yes, ma'am.
Okay. Permission to approach?
May. You need those marked, Ms. Robinson?
Yes, please.
Okay.
More photographs in the two.
So exhibits A and B.
That's fine. That's easier for the court. Thank you, ma'am. Officer, I'm going to show you what's been marked as Defense Exhibit A and Defense Exhibit B, the proposed exhibit at this time. Do you recognize these pictures?
Yes, ma'am.
Are they a fair and accurate depiction of how Melania looked on the day of the alleged incident?
Yes, ma'am.
Your Honor, at this time I would move to introduce Defense Exhibit A and Defense Exhibit B into the record.
A motion to admit defense exhibit A and B. Any objection?
No objection.
Without objection, defense exhibit A and B are admitted into evidence.
And you stated that you took these photographs, correct?
Yes, ma'am.
Okay. And you also stated that you saw blood on Melania on that day.
Yes, ma'am.
Okay. Can you point in the picture where you saw blood?
So it would have been on the right side of her face as well as her right arm.
Okay.
But
Go ahead.
if I may, she had wiped off the blood because it wasn't her own. So
Okay. So there, you weren't able to get any photographs of Melania with any blood on her.
no, ma'am.
Did you observe any rags, towels, anything that would have been used to wipe off said blood in the vicinity?
Yes, ma'am.
Did you take any pictures of those?
No, ma'am.
And again, why didn't you take any pictures of those?
Didn't believe it's necessary, ma'am.
Okay. Well, would that not be considered evidence in a crime?
Honestly, I wouldn't have seen it as that sense. No, ma'am.
No. Okay. So Ms. Melania, or Melania, I believe that she's told you that she was assaulted by Mr. Jones, correct?
Yes, ma'am.
Okay. And that you saw her with blood on her.
Yes, ma'am.
Okay. But by the time you took those pictures off, she had wiped that off.
Yes, ma'am.
So to further corroborate her story that she had blood on her at the time,
Well,
wouldn't it be beneficial to take those pictures?
if I may, ma'am. So when she had first came and I first saw her, she had the blood on her still. It was while I was interviewing her. She wanted to wipe that off just for her sake, more so.
So you didn't take any pictures of her before,
No, ma'am.
and you didn't take any pictures of any sort of towel, rag, or blood.
No, ma'am.
Is that?
Did you want to publish those exhibits?
Yes, thank you. Published Defense Exhibit
Thank
A
you.
and B. Yep. Now, you also stated that you, or that Melania, you were told that Melania had a tire iron and hit Mr. Jones with that said tire iron, correct?
Yes, ma'am.
Did you find the tire iron at the scene?
Yes, ma'am.
Did you take that into evidence?
Yes, ma'am.
And did you take photographs of that?
Yes, ma'am.
Were any follow-up tests done on the tire iron?
Not that I'm aware of. I'm not sure.
So was the tire iron ever sent to like a crime scene technician or lab for further fingerprint testing?
Objection, relevance, Your Honor.
Response?
Your Honor, it goes to probable cause, as it would show who is in possession or possibly in possession of the tire iron.
I'll allow it overruled. If the investigation leads to an analysis of the tire iron, I think the officer, if the officer knows, he can answer that.
Would you like me to repeat the question?
No, no. So as far as I'm aware, there was no further analysis that was done on him.
Okay, so it was just turned into evidence and it just remains there today, correct?
As far as I'm aware, yes, ma'am.
At any time while speaking to Mr. Jones, did he mention that he ever assaulted Melania?
I mean, I wasn't questioning him or anything like that about the case itself, but I mean, out of the time he was just speaking normally, he said he never assaulted her. That was correct.
Okay. And did he make any statements about assaulting Leilani Milton?
Nothing more.
Are you aware if a PBD was a PBT, which is a preliminary breath test, if that was conducted on Mr. Jones?
I'm unsure, ma'am.
And are you aware, or were you aware at the time of the extent of Mr. Jones's injuries to his face?
I mean, on arrival to the hospital, yes, I suppose.
Do you know if any additional treatment at the hospital was conducted, let's say, for instance, like stitches or surgery?
I mean, prior to me leaving, none of that had been.
So when you left the scene, another officer came to Sparrow, is that correct?
Yes, ma'am.
Do you know which officer that is?
Officer Ozentowski.
Nothing further.
Any redirect?
Yes, Your Honor. So officer, to clarify, on Moniana, you did not observe, the blood you observed on her did not come from her.
That's correct, sir.
And you did, what did you observe? Some marks on her? What did you observe on her?
Mark under her left eye, as well as scrapes and marks on the right side of her face, as well as her neck.
And there were some photos you reserved. Do those accurately reflect theirs or anything with the quality of the photos?
More so the quality of the photos.
When you saw them in real life, can you compare when you saw them in real life to how they looked in the photos?
To a certain degree, but it's difficult to see everything.
In real life, were they more pronounced, less pronounced? Looked about the
More
same?
pronounced.
And on the same line, did you notice any injuries to Liliana?
Yes, sir.
What were those injuries?
Liliana had a scrape under the right side of her chin, closer to her neck, as well as a mark on the inside of her lip, where possibly from something hitting it and it hitting her tooth caused an injury there.
No further questions, Your Honor.
Okay. May this witness be excused?
Yes, Your Honor.
Without any objection to the witness being excused, Ms. Robinson?
No, Your Honor.
Without objection, the witness is excused. Any further proofs, Mr. Witsi?
No, Your Honor.
Do the people rest?
Yes.
Any proofs today from the defense?
No proofs, Your Honor.
All right, motion for bind over.
The people would move to bind over on both counts, Your Honor. The child abuse third degree, the elements are the defendant. The elements are care, custody, or authority of the child, intentional harm, and the child is under 18. We heard testimony pursuant to the statutory hearsay exception that the defendant lived in the same household as the child. The child was 13, and that there was a fight here where I think intentional harm was certainly demonstrated by the testimony. This is unrefuted testimony at this point in time. And you've got the elements there. It's a child in the same household. He's got authority over there. He strikes her. That's intentional harm. And she's 13 years old, which is under 18. We'd also move to bind over on count 2, the domestic violence. We will not move over because that's still a misdemeanor, Your Honor. This is solely about count 1.
Thank you. Response?
Yes, Your Honor, I would state that I don't believe that there has been probable cause to bind this case over. There's been inconsistencies with the statements and what was told to the officers. Further, we only have what was told to the officers. The victims are not present here today, even though they were subpoenaed. So because of those inconsistencies, including about the bite marks, and where exactly the assault occurred, whether it was upstairs, downstairs, it seemed like there was some mixed testimony regarding that. I would ask that you find that there is no probable cause at this point and not bind over.
All right, so the standard for preliminary examination in file 22-01974 is probable cause, that being the second lowest standard in criminal law. I don't think there's any dispute of the allegation that the location occurred at 900 Long Boulevard, apartment 321, the venue in the city of Lansing, state of Michigan, Ingham County. The defendant was identified, and this all occurred on July 26, 2022. Through hearsay testimony pursuant to statute, it appears that Officer Matthew Stevens indicated that her name is Lelania Christine Mitchell Milton, was 13 years at the time, and that she was in the care and custody, or there was authority over her at a probable cause standard at the time, and the defendant either knowingly or intentionally caused physical harm. There was testimony that he hit her in the face several times, both upstairs and downstairs. Upstairs seems to be the real testimony here. As to downstairs, it seems to be part of the domestic, which is the 1 year which the court is not in front of the court today. But I do find by a probable cause evidence that the defendant knowingly or intentionally committed an assault and physical harm to the child, Lelania Christina Michelle Milton, who was under age, so 17 or under at the time, under the age of 18. I find that the people have met their burden for probable cause and the identity of the person who committed the crime. So I will bind over on count 1 to circuit court. Count 2 will follow as a 1 year misdemeanor, and I don't have to bind that over. So count 1 is bound over to circuit court, and the arraignment date will be left to defense counsel. Anything else for this file? Docket 22-01974, Mr. Whitson.
Nothing from the people, but I believe the defense to want to address.
All right, Ms. Robinson, you wanted to address bond in this matter?
Yes, Your Honor.
Okay.
I would ask the court to consider giving Mr. Jones converting his 10% bond into a PR bond with GPS tether. He has already qualified for the GPS tether and has spoken with them and is able to receive that tether immediately if he were to be released. He has a relatively low 10% bond of $3,000, which would only mean that he would have to post $300. However, he is indigent and he can't afford to post that $300. So we would ask that you convert that over to a PR bond. As we saw today, the victims were not present here for this hearing in which they were subpoenaed. Mr. Jones has the presumption of innocence in this case. And I believe there are some facts that we can that would make a great self-defense argument in the future. So we would ask that you allow him to be given a PR bond, because it really is a low 10% bond. And, but for the fact if he wasn't indigent, he could be out in the community fighting his case. And because of the fact that he's poor, he now sits in jail and can't post that bond. And I think a GPS tether would adequately supervise him in the community, making sure that he's staying away from the areas that he needs to stay away from, as well as pretrial services reporting.
Thank you, counsel. And I've looked at Judge Ward. Judge Ward set the bond at 3,010% cash surety. I think that's a fair and accurate bond in this matter, especially under bind over under these circumstances with 2 domestic victims, essentially. So I'll deny the reduction in bond and bind over to circuit court. Bond can be taken up again, once again in circuit court in this matter. Anything else on the record in docket 22-01974? Mr. Witzy?
No, Your Honor.
Ms. Robinson?
No, Your Honor.
All right, that's all for the record, Ms. Fowler.
No, so he-
Got it. We're on the record in docket 22-01982. People of the state of Michigan versus Nathan Kreit. Will the parties please introduce themselves for the record?
Jake Wisty on behalf of the people.
Good afternoon, Your Honor. Jacob Sarch, the fourth Assistant Public Defender, here on behalf of Mr. Kreit. Mr. Feigelson is unavailable this afternoon and this morning due to some medical issues. Very sorry about all that, Your Honor. I have had the opportunity to talk to Mr. Kreit, advise him of plea offers of the proceedings today, get a chance to go over the discovery with him. From what I understand, Mr. Kreit, you're okay with me stepping in for Mr. Feigelson today, correct?
Yes, sir, I am.
Okay, thank
All
you.
right. And sir, you are Nathan Kreit?
Yes, sir, I am.
All right. This is the time set for preliminary examination today. Mr. Wisty, how are we proceeding?
Your Honor, the parties would be seeking an adjournment. There was a misdemeanor offer made. My understanding is the defendant is interested in, but there's another pending case, possibly two pending cases, one involving some contact in the jail. And we just need an adjournment to seek a possible resolution rather than sending it up at this time.
Your Honor, I would clarify, though, that I just talked to Mr. Kreit. Mr. Kreit would respectfully request his preliminary examination. However, on behalf of Mr. Kreit, as his counsel, I am very concerned about this other case that is apparently out there that may be issued very shortly. I'm concerned about the potential discovery issues. And I'm also concerned as well about these allegations of these jail calls. In terms of the plea offers, I had been expressing interest in some type of global resolution. Mr. Wisty at this time is unable to make an offer along those lines. Mr. Kreit, though, is requesting his preliminary examination. Of course, whether that's a good cause for an adjournment, I'll leave that to the court's discretion. But just to make it very clear, Mr. Kreit is asking for his preliminary examination. Thank you.
All right, thank you, counsel. So it's my understanding that that there are offers been made. There are two pending files.
Your Honor, if I can clarify.
Sure.
There's a pending case coming that has been signed and sent off through that process in our office involving similar conduct of the same victim. There's also, I think, perhaps the best reason for an adjournment being good causes. There's jail calls here. We have recordings where he's making statements that I believe could be interpreted and found by a jury telling the witness not to be here. We did have an officer prepared to go without the witness, but I think these new allegations, these phone calls, we discovered them earlier this week, are good cause in and of themselves for adjournment. Basically, he may have contributed to the witness not being here.
Is your officer here right now?
I let him go, Your Honor.
Okay. Was that Officer Rydell?
Correct.
God, I saw him here earlier. I believe, so it is your contention, Mr. Kreit, that you want your preliminary examination today?
Yes, sir.
All right, thank you. I find there's good cause to adjourn. I'm going to seek just a 1-week adjournment in this matter. For discovery issues A, there are jail calls they're outstanding. Also, there's also at least one pending felony file that has been signed pursuant to Mr. Kreit. I'm not sure about the second, but I think we were able to confirm that it looks like there is, or at least one signed warrant. Okay.
Yes, just for clarification, my reference to the second would be potential charges coming out of the jail call.
Okay. Okay. So those would be the second would be the jail calls themselves.
Yes. And
All
that's
right.
still basic. That's in the investigation stage.
All right. So I find good cause to adjourn 1 week. Cause to adjourn 1 week. 1 week in this matter.
August 18th.
So August 18th at 9 o'clock. I recognize the defendant has not waived the right to a 21-day to examination within 21 days. And so I find that discovery, good cause, and pending charges are good cause. And so I will adjourn this 1 week to August 18th at 9 a.m. Anything else for the record, Mr. Witzy?
No, Your Honor.
Anything, Mr. Sarks?
Thank you, Your Honor. May I be heard on bond?
You may.
Thank you. On behalf of Mr. Kreit, I would respectfully request a reduction down to personal recognizance bond with GPS tether. Respectfully, Mr. Kreit has a job that's waiting for him if he can get released. This is obviously a very complicated situation with possibly another case forthcoming, but at least in terms of this file, at least if he only gets a few days, you'd like the opportunity to get out try to pay down some of his financial obligations, try to reestablish possibly some housing, get his job line back up again in the event that he is able to stay out on bond for the duration of the case. Obviously, the situation is quite complicated here, but if, Your Honor, if the parties are able to negotiate something at the district court stage, it's a possibility perhaps that this case may remain at district court. And if Mr. Crichton is out and if he's working and if he has a stable place to stay and if he can, and I'm very optimistic he can comply with the court orders and present to Your Honor a very clean track record of complying with the orders, perhaps that might open up some additional opportunities for him. He's already served approximately 3 weeks of time already. He's financially indigent, so any sort of significant cash bond he would be unable to post. And if this other case does get issued combined with this current case, Your Honor, and he's of course presumed innocent of all these allegations. These are just allegations at this stage. We're still at the district court level, and it could be a very long road depending on how the case proceeded. If down the road Mr. Crichton needed a jury trial on this case or any other possible case, it could be a year or longer. So based on the expected delays, based on the time he served already, and a lot of other factors, respectfully, I would request a reduction down to PR bond for him with GTS 10.
Thank you. Response?
Yes, Your Honor, these are very serious charges. There's other allegations. This isn't of this type of behavior that he's demonstrated. He's made phone calls already defying court order and I think knowingly doing something that he's not supposed to do. I don't think a bond is any evidence he'd abide by any sort of bond conditions. I believe bond should remain as is.
And I'll just state that those are only allegations of these calls, and of course, Mr. Crichton is presumed innocent as it relates to those allegations. Thank you.
It's fair enough. I find that there's two prior. I do look there. It's a 10-year and a domestic assault, and then 2 priors on the domestic assault, with outstanding jail calls as being a basis for a possible potential further felony. I'm going to deny the motion for bond and continue as is at 10,000 cash or surety as it is right now. Anything else for the file in docket 2201-982, Mr. Wisty?
No, Your Honor.
Mr. Sarts?
Nothing further.
All right, we'll see you next week.